revision or a review of what we have done for the course aspects of contract and negligence for business, that is BUSN 4050. Okay. So the agenda is we will try to do the self-assessment, which is objective test. Okay. Then we do the test 1 and we do the test 2. It's basically a review. Okay. So we already done the test. We check what are the answers right or wrong and how to go about it. Okay. Then we come to the discussion forum where I posted some questions. So we try and answer it. Then we try and answer our assignment. Okay. Which is the primary goal of this. And the whole thing we are recording, so we know who is interacting, how much there is evidence for your assignment. Okay. So we start with first one is the self-assessment 1. Okay. So we will take it one by one. We will answer it and get the logic why it's right or wrong. Okay. Because that will help us to get the right answer. So this was the match the following. So given us terms, that is either implied by certain items here, and we got the choices. Okay. The first one is saying, okay, term that is neither implied by common law on the basis of business efficacy or statute and is inserted in a contract as a matter of law and irrespective of the party's intentions. Okay, so which is the right one? Or if you're not sure, the best way to do a match the following is do the ones which you know best. Okay. So let's leave the first one. Okay. By matter of choice, you can come back to that. So second one, dash term that has been actually agreed to by both the parties to a contract. Okay. So which is the one you think?
Condition?
Condition? No. It is express term. Express means is saying that term that has been actually agreed by both the parties to a contract. For example, let's say in an employment contract, what is express is payment of salary. Right? Salary is an express term because it's very clear. Let's say we agree, the appointment letter says that I pay you salary for 20,000 per month. Okay, so it is an express term. So there's nothing implied about it. Okay, so we mark that
Express term.
express. Okay, next one. Dash is the intermediate term which cannot be defined as neither a condition or a warranty. So this we clearly know that it's a innominate. It's somewhere in between. Okay.
Innominate.
Yeah, this is by definition. An innominate term is a term which is by definition either a condition or a warranty. A condition is a term which is a major clause. It goes to the root of a contract. You know, it's like this. Like suppose I say that you work for this much hours, I pay you salary. So that is a condition. What it means is if I don't work for 8 hours, then I am not eligible for that salary. Okay, so it goes to the root of the contract. Whereas the warranty is not necessary, it doesn't go to the root of the contract. Of course, it says that if I do something wrong or I leak some confidential information, okay, so that's a warranty clause. Okay, or if I expressly write in the contract saying that if you leak out confidential terms or confidential papers of the company, then I say I make it as a condition. Okay, or suppose you misbehave at work. So if you misbehave at work, can I remove you from your job?
No.
I can only take disciplinary action. I can suspend you. I can take you, send you to HR, find out what's wrong with you. So I'm not able to end the contract. So warranty is that. So a condition goes to the root of the contract. It's a major clause, and a warranty is the other extreme. It's not very serious, but then still a matter of. Innominate is somewhere in between. Okay, that's why we marked it here. Dash are the minor terms of a contract which are not central to the existence of a contract. So obviously just now we said it's
Warranty.
Warranty. Okay. Next one. Dash is a major term of a contract. So just now condition.
Condition.
By definition. Okay. These are all by definition. So there is no argument on that.
Condition. Is an express.
So is an express term of a contract that purports to exclude or limit the liability. As I told you,
Exclusion.
is the exclusion clause, because I try to limit. I say, okay, you as a salesman, you go to do a job, and suppose that you sell something and you don't fix it properly. So I say I am only eligible to give you compensation for this much, because it doesn't stand in court naturally, because you are trying to limit your liability. Or you go by bus. They say, bus fellow will say, okay, I am not liable for any loss of your belongings. If, or airline will say that if your baggage is lost, we are liable only to an extent of 10,000. Now, for all you know, you must be carrying a lot of valuables, gold, everything. But he is saying, I will not agree to everything. If there is a loss and I am not able to give you baggage, then the limit is 10,000 dirhams. You understand? So I am limiting it. So that's an exclusion clause. Okay?
Liability.
So what is left?
That's the implied sentence.
Implied term. Okay? So that completes the first one. So next one, a contract implied by law to prevent unjust enrichment
Quasi.
is a quasi contract. Basically, what it means here is, suppose you try to enrich yourself. Let's say you have a vending machine, okay, or you come out with a website where you log in, okay, you go and you ask for credit card details, you give the credit card and everything, and then nothing is happening. Suddenly you lose money. So those kind of contracts, okay, where someone is getting enriched, okay, it's called a quasi contract.
Quasi contract.
So only problem is this is slightly case sensitive. Okay, so the way you write it is like this, or you write all capital. Okay, next one. Acceptance is the essential element in the formation of a contract, and acceptance may be in the form of a written promise or in the form of performance.
That's true.
True. Okay. Because that's essential. Unless you perform or you accept it, it's the first. There's offer and acceptance. That's the essential of any contract. Okay. So in Cartier versus chemical cleaning, the apprentice took a wedding dress to be cleaned by the defendants. He signed a piece of paper headed receipt after being told by the assistant that is exempted the clearance from liability for damage to beads and seconds. The receipt in fact contained a clause excluding liability for any damage whatsoever rising. So when the dress was returned, it was badly stained. The cleaner had to pay damages. Yes or no?
That's true.
True.
It's true, because you need to you damage the cloth, so you have to pay the. You cannot exempt yourself by saying it's not my mistake.
That's the responsibility.
Okay. So next one is Hong Kong Fifth Shipping Company versus Kawasaki created the concept of an innominate term. In this case, the defendants chartered a ship for 2 years from the plaintiffs. In the agreement, there was a clause stating that the ship was in every way fitted for cargo service. Over the course of 2 years, 20 weeks of charter was lost due to problems with the engine and incompetent staff. This is an example of innominate clause. True or false?
True.
True. Okay. Because it is what happened was the contract was for 22 years, out of which 20 weeks they lost. They lost because the ship was not saleable for various reasons, but it was very less amount. So out of two years means is about 104 weeks, out of which 20 weeks is a small amount. Maybe they cannot end the contract, but they can say, okay, we compensate. Okay, which was not, in that case they wanted to end the contract, they said there is no contract. Okay, so that was the fight. So that was the answer for the first assessment. Okay. So as I said, it is case sensitive, so maybe the answers. So luckily it's 5 out of 5. Okay. So we go to the next, the test one. So as I told you, this is one way of learning.
And this is
Okay.
this is
So how we learn
one.
doesn't matter. So this is one of the ways you're learning. So we are also capturing the video. So there is interaction. So you're giving some answers. We are discussing it. So that's evidence that there is learning being done. Okay. So terms and conditions within an employment contract can be derived from a number of sources, which may include. Okay. We are asking you to select one of these. The terms within a written or oral express agreement, terms implied by law relating to relationship between the employer and employee, duties of fidelity and good faith, terms implied from the custom or practice of the business or a particular industry.
So it's all of the above.
So all of the above. Because I just want to say something about each. Okay, the terms within a written or oral or express agreement. Now there are, let's say there is an employment contract. Okay, so it's very difficult to write everything in the employment contract. You understand? There's some things which we, like for example, let's say I appoint Maria because she's passed a master's. Okay. Let's say for example. Okay. But then in the contract I am not saying that I am giving you this appointment because you have passed masters. But I have asked you in the interview and you have confirmed that you have passed the masters. So that is part of the contract. You understand? So it's not necessary that only in writing, but also the interview, also exchange of letters, emails, for example. Okay, all that is a part of the whole contract. Okay, because you have got evidence, you can always come back to that. Okay, because in the interview, it may be 1 or 2 or 3 people who are witness to that. So even if it's oral, they can always build up with a witness. Okay, or maybe it's also recorded. We don't know. Okay, so here it's all of the above. Why? Because first one I told you, terms implied by law relating to relationship between employer and employee. This we said that was the second of the requirement and agreement. When you have an agreement, the relationship should be legal.
Legal between.
Okay, so it is very clear the employer and employee in the employment contract. Okay, duties of fidelity and good faith. When you are doing any job, obviously they want to do a lot of things which you are doing in good faith for a salary. They don't expect you to do something wrong. Okay, so that's very well conveyed. Then terms implied from the custom or practice of the industry. Like it's very clear that if I give you a job, I should give you a place to sit. Because that's a norm of the industry. I should give you an environment where it's not too hot, it's AC, there's safety. I don't give you a building which is all broken down and say, okay, Yusuf, you come and sit here and work. So Yusuf is not going to come because he's scared. First of all, second thing, it's not executable in the court. Okay, so that's why all of them. So dash are not expressly included in the contract, but they are nevertheless still part of the contract. So there are a lot of terms like implied. For example, I don't say how you behave at work. I don't write that you should wear uniform and eat this and don't disturb the neighbors and don't do this and that. Don't talk rudely to people. Those are not said, but it is implied. So when you do a job, it's understood that you maintain the decorum of the office. You behave in a way which is in a matured way in the office. All that is not written in a contract, but it is understood. So again, so we say it's implied.
When I put implied, it was wrong. That's not
Is it?
Yeah.
I said that's why I said it is case sensitive. So don't worry about
Because I
that.
did it with small letters.
Maybe spelling.
Maybe spelling mistake or it doesn't expect. It takes it this manner, or else you write all capital.
Yeah, I put it all small letters. So maybe that's
So it's not case sensitive. That's mistake, technical problem of the. Okay, so you don't worry about that. Oral contracts are not legally valid. Is a oral contract a contract?
It's false
It's-
because it's always wrong.
Yes, a oral contract is very much a contract. It has got all the ingredients of a contract. Only problem is it has to be proven. In case there is a problem, it has to be proven in court. So neither you collect witness or you have tapes, okay, or you arrange for some sort of a backup. Okay, so that's. A dash is an express term of the contract that purports to exclude or limit the liability.
Exclusion.
Exclusion clause. Excellent. So just now I gave you example where people try to exclude themselves from any problem. Like for example, RTA may say that anything lost in transit is not responsibility of the taxi driver or the taxi. But then it doesn't stand in court. If you prove that you have gone in that taxi and you have kept,
This question in number 4,
Yes.
question number 8.
yes, it shuffles.
تتخربط ترى مو حاطبها.
It will not come in the same format. When I take, I will get different sequence.
Yeah.
You will get different sequence.
Search يعني.
Just to encourage, just to make sure that you don't say A, B, A, B, A, B like that.
After you log out, it
Yes.
comes in different.
Just to make sure, it shuffles.
Yes, it's hard.
So that's why I am trying to explain the whole thing so you understand. It is a learning process, right? Sometimes you learn by reading, sometimes you learn by doing this kind of quiz. It's similar to you buy a CD and that's how we learn Arabic and all, right? For a child, for let's say ABCD and all. How do we learn? You have a song,
Memorize.
memorize, so you put a CD and you sing along. That's another way of learning.
We have materials as well.
Huh?
Materials.
Yes. So it's different way of learning, that's all. A dash is an agreement which can be legally executable in court.
That's a contract.
A contract, very much, because agreement is just a form of a contract but not formalized contract. Okay. But a contract is an agreement. An agreement has to be a contract when it got all those essentials, like offer and acceptance, consideration, legal relationship, right? You've seen all that. Okay, so we write a contract. See, if I even write all capital, it still will work. Essentials of contract are often an acceptance, intention to create relationship, capacity, privacy, privity of contract and consideration. So this should be privity, not privacy. Okay. So that's a mistake. I told you it's, so we are developing it, so there may be a lot of problems. Okay, so you know what is capacity, right? More than 18 years, should not be alcoholic, should not be under the influence of drugs or medication.
But there's a way they can change the capacity to something else.
No, that's a legal term.
Yeah.
When you say capacity means it is in a capacity to do something, to execute the job of signing. Yeah. In that sense. Okay. Brevity of contract, what we understood that a third person cannot come and execute it. Suppose, let's say I have a contract with you, your wife cannot say, come in between and say, okay, now you pay on behalf of this.
Yes.
It can be done provided you give her power of attorney. Then it's between still you and me. But she is only accepting in your place. She cannot on her own come and say, okay, you pay me this is money. That's not agreed. Okay. And consideration, you do a job, there's money in exchange.
Give it back.
Okay. So that's a consideration. So it's all true.
True.
Essentials of a contract. So if a warranty is breached, the innocent party may claim damages but cannot end the contract.
True.
That's true.
Okay, why? Because,
Breach.
can you give a reason? Can you give an example? So warranty is breached, the innocent party may claim damages but cannot end the contract. Like I told you just now, let's say,
They cannot basically exclude yourself from the responsibility, so you have every right to win the damage, but you cannot
Yes.
still end the contract.
see, it's not a major thing in a contract. You know, if it's not a major thing in a contract, I cannot end the contract, but I can claim for damages. Like the example I said, let's say someone is working as a night shift, okay, and he sleeps on the job, and there is a problem. Okay, something happens or a small fire, so I say, okay, you're sacked. I cannot.
But then on what terms can you end the contract?
End of the contract when it says very clearly that you are going to come at night and you are not supposed to sleep. Then
So
I
you
put it
broke-
as a condition.
You break your contract.
When I say it's a condition, it is expressed very clearly. For example, if it's a security, I don't expect him to sleep. So it's very clear clause saying that you don't sleep on your job. Because that's your job. If you sleep, then what kind of security is that? Whereas any other employee, if falls asleep, then you cannot end a contract. I can suspend him, I can take him to task, I can cut his salary or something, I can ask for compensation, something goes wrong. I cannot say, okay, you're sacked. You understand? So warranty clause is not a major deviation. It doesn't go to the root of the contract. Whereas a condition is a root of a contract on which the contract has been made. If something goes wrong, then the whole contract is ended. You've got no choice but to end it. You understand? So that's the difference. So if warranty is breached, the innocent party may claim damages but cannot end the contract. True. So express terms of the contract of employment will not include what? See, timing, obviously it is main. 8 hours of job and reporting from this time to this, it's going to be returned. Salary will be returned, right? Holidays will be mentioned in any contract. So behavior at the workplace,
That's not going to be.
that's not going to be mentioned. It's only understood, it's an implied term. Okay? So it's not an express term but an implied term. Designation, of course. I say you are a branch manager, you are whatever.
Behavior and
Yes.
at the workplace.
So behavior at the workplace is implied. So the beauty of a written contract is that it serves the dual purpose of both the promise and proof of the promise or evidence. It's very clear. So when it's a written contract, I got proof. When it's a oral, I got a problem. Because I may not have a proof. I need a recording, I need to do so many things. Okay? So that's why it is
That's
True.
true. So you come to the last one. If a condition is breached, the innocent person is entitled to,
You can end the contract.
Reputate and the contract.
you can end the contract obviously because it's going through the root of the contract. Okay. Now why it is not, he can also claim damages, but I am saying select one. So obviously I try to end the contract first. I may claim damages, I may take him to court and all. These two is subsequent to that. But the first thing I do is end the contract. Okay. So that's why. Okay. So you can stop the video.